Obviously, we will be looking to depose the plaintiffs, and Mr. Diller and I have been in discussions as to the timing of all that, but we have not taken any depositions yet.
I think that's interesting, and I wonder if that indicates that the two bars are pointing the fingers at each other. It would only make sense, in order to reduce your culpability, liability, that you would want to point the finger at the other. And I wonder if that's what's happening here.
Possibly. I mean, yeah.
Attorney Daly?
It's Attorney Hassett, Your Honor. We've noticed 4 depositions, Your Honor.
And this is the attorney for the waterfall.
There are witnesses at either of the bars in question on the evening and morning that's relevant to the case. And we've also noticed the deposition of the state police toxicologist who did an retroactive extrapolation.
That is really interesting to have the state police toxicologist. I'm surprised they didn't hire their own toxicologist. I've actually done some litigation with regard to people have been consuming beverages, shall we say, and then they're in accidents. So, that reverse extrapolation goes to whenever the blood test or BAC was taken the next day. And toxicologists use science to go back and find out what the BAC likely scientifically would have been at the time they left the bar. That's really relevant. That's extremely relevant testimony.
And I believe we have one keeper of the records out, Your Honor, but the documents, I think, in connection with that have already been produced. Those depositions are scheduled to take place early July.
Who's speaking for Ms. Reed?
I am Attorney Rosenberg, Your Honor.
What depositions have you noticed? Which ones have you taken?
So we've noticed all of the depositions that we previously identified. We'd already had them noticed as of the last status conference. The first one that we have is actually coming up on this Tuesday, and then we've got them scheduled, as Mr. Diller said, the bulk of the summer, and Mr. Diller's recently noticed additional deposition. That are, for the most part, after the ones that we've noticed. We'll have.
So the very first deposition, even though this case was filed back in 2024, the very first deposition is scheduled for April 14th. So they've only got 4 months to do all the depositions because the close of discovery is scheduled in mid-August. So interesting.
We'll have some dates that are going to have to move and have already had to move because of various people's availability, but we've got all of them locked in, relatively speaking, between roughly next week and the beginning of July.
I didn't hear anyone say that they've taken a deposition.
Nope. Like I said, the first one I think will be this Tuesday. It'll be our deposition for Ms. Reed. But that's, as you asked, I forget if it was Mr. Diller or Ms. Holstag, that's primarily because when they were initially noticed, it was after today's date.
Forget when I got involved in the case. I know it was sometime in the fall. I know we talked about discovery and depositions then. I guess you all just desire to ruin your own summers because you're going to have to get a lot of discovery and depositions done by the summer.
Am I right or wrong? Did that sound like a little bit of a scolding or just a chiding?
Well, kind of chiding, scolding, a little bit of both. I wouldn't want a judge to tell me that.
No.
Because he's basically saying, look, you're going to have to get it done because if you don't, I'm not going to continue the trial.
More interestingly to me is that the Massachusetts Superior Courts, and I have some cases pending there, so I do have to be a little bit careful about what I say, but I mean, some of the cases in the Massachusetts Superior Courts can drag out. I've seen cases, and I'm not going to mention any counties, but some of the litigation, civil litigation in the Superior Courts can drag out for quite a while. And in that, there were stays, and I'll talk about that when we're done with the video. It's a little bit surprising to me because discovery can be usually, not always, but discovery in the Massachusetts Superior Courts can usually be enlarged at least once for good cause. And it would seem good cause would be that there was the stay due to the pending criminal court, and that there are so many parties and scheduling can be difficult. So it's a little bit surprising to me. I have seen cases go for quite a while and discovery be at least once continued, not as of right, but it is allowed at least once. And then after that, the court is a little bit more skeptical about why you're doing it. But yeah, the tone that I'm getting here is, don't come to me in August and ask me for a continuance or an enlargement of time for the discovery when I've been, holding these status conferences regularly and making it clear that I want to know what's going on. So,
yeah, and it could be that the judge is just being hard on them to get them going, to start this case with the depositions, because, he wants to make sure that the case is moving and it's not stalled in his courtroom. That may not mean that he won't continue it, but he wants to give the impression that, look, you need to do this.
Well, but then you can't. There's a situation here where Michael Proctor, former Massachusetts State Police, believes that he has a right of privacy to any communication that he had while he was a Massachusetts State Police. Most of these people are failing to understand, when you are a civil service government employee or a federal employee, you don't have any privacy when it comes to documentation that is required for court, for cases, for anything. If you were or are employed by any of the agencies, government agencies, and they require your stuff, and you fail to use your stuff professionally, you're roasted, because you're supposed to turn them in. There's no privacy on your end. You're supposed to turn it in. So why are they still sort of hiding under the fact that they were MSPs and they were government and they were Norfolk County? Get the dang communications. Hey, Mark Diller, get the dang communications. Pass them to the defense lawyers. You started this lawsuit, right? Right? So if we are asking those people to succumb to anything that they have because it's evidence, it's part of the discovery, why is it taking this freaking long for them to supply what is needed? Why? Why are you all of a sudden dragging your feet? You spent the entire second trial sitting like a decoy on Karen Reed's trial, watching, observing, taking notes, and doing all you had to do, right? To what? To now come to this point where you're lagging? You're worse at a caravan of molasses, dragging your feet and not doing what you're supposed to do and failing to share discovery material with a defense lawyer. This is all your fault. But the judge is going to come down and very hard on you guys.
Come on, speed it up.
Yeah, you said it more eloquently than I did.
I mean, that's what I mean.
Issues?
Go ahead. Sorry.
That was the judge interrupting you, not me. For once, I didn't interrupt you. It was the judge.
Your Honor, Plaintiff Mark Diller here. We also have a pending
Oh my God.
motion,
Come on, man.
or not a pending motion, excuse me. We have a pending subpoena to the Norfolk District Attorney's Office relative to the matter that they're prosecuting against Mr. Carney, Aidan Carney. I've met and conferred because they stated that they cannot produce a number of those documents.
Oh, surprise, surprise. They now, the O'Keefe's attorneys say they want information out of the Norfolk County District Attorney's Office with regard to the Aidan Carney prosecution, which is actively going on right now. And the Norfolk County District Attorney's Office is resisting them. What a surprise. What a shock. Are you falling off your chair out there in California, Yoli?
Well, yeah. I mean, well, okay. It's just, this is so messy. That's all I'll say.
Okay.
Because there's a pending prosecution there. So we've talked to them. We're going to try to intervene into the criminal matter to seek access to those documents that were obtained through the criminal investigation pending against Mr. Carney.
Speed it up.
Now, I wonder if he just means, I wonder if Attorney Diller just means, informally, as though I would just ask you some questions and pop into your office, or if he means a formal intervention into the lawsuit. I wonder what he means.
I would think that if he's issued a subpoena for documents that are involved in the Carney criminal case, that the subpoena was issued from this civil case, so it should be enforced through this court. In other words, they should file a motion to compel those documents, and then pursuant to the subpoena, and the judge needs to make a determination as to whether or not these third-party documents are discoverable, and then that gives the opportunity for Carney's counsel to object, but it has to be done through this court. I don't know what he means by you can't, you don't intervene. You don't file a motion to intervene in a criminal case just to get documents. You have to have some interest other than seeking documents, because you could do it through a subpoena and then file a motion to enforce the subpoena.
He's delaying the
motion to compel.
That's what he's doing.
And then this judge would hear it subject to the objections of Carney's counsel.
But this is the first thing that I want to point out. So this hearing happened on the 9th, right? Look at the date on this personal order issuance date. Thursday, April 9th. But when you look at the effective date, it says 8th. How can you backdate effective date? You can't do that. This was done because of this hearing. This is a proactive way to try to avoid any further shame to come back and bite the MSP on his behind. Or on its behind. Not only that, intervene in another criminal case to do what? Why do you have to intervene in a separate criminal case? If you need any documentation from that case, then you request it. And most of the stuff is typically impounded, right? So what are you trying to do here, Diller? Delay the whole thing further or justify your lack of efficiency? Which one is it? Like, come on. Oh, it's going to make sense in a minute. Go. Here we go. So this was the hearing. Again, take note. This happened on Thursday. And Thursday was April 9th, right? So April 9th is also the date, right, of this personal order. But the effective date is a day prior. That does not follow standard operating procedure of anything related to retirement, personnel, nothing. That doesn't happen. If you're going to issue something, the date of the effectiveness should be a future date, not a past date. That's the first boo-boo, but we're going to identify a couple of more. Let's go back to this. Okay, so what happened here was there was a hearing, and that's just following the chronological order of events. There was a hearing in regards to Karen Reed. This hearing was a closed Zoom, right? Like everybody can see it here. There is no live streaming of this hearing, blah, 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 rule, blah, 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 blah. So a couple of people started to show it, like Young Yerks and whatever, and then they had to like log out. But that is the context of that hearing. There was a deposition that was scheduled, and even though the lawyers were trying to backpedal and not to come straight forward and say When were the depositions scheduled? Who was going to be deposed when and when? Did they have any depositions scheduled? The judge asked, who is the deponent? At that point, none of them could, try to like skip the question and not answer it straightforward. So they had to say it was Brian Tully who was scheduled for the deposition that they were planning to have for 2, 3, 4, 5 days, whenever. 3, 4, 5 days. The judge is talking about 5 hours. These lawyers are saying that this deposition may take more than a day, more than 2 days, more than 3 days, and perhaps 4 or 5. But the judge said, well, by 3 o'clock, I want to hear this motion on the 7th. What does that mean? So all of a sudden, you get Howie Carr posting what he found from Colonel Jeffrey Noble, right? Perhaps anticipating the chaos that is going to come up, is going to surface after they depose Brian Tully. So if you look at the calendar, and we know that the 9th was when the hearing happened, and the 9th is when that personnel letter is being redacted on behalf of Tully in regards to this law, that we're going to take a look at this law. Because in order for us to understand how shady all of this is, if you don't understand what is the process, what does it entail for somebody to request retirement, what merits it, if you don't understand the little thingies here and there, then you're missing the whole enchilada here in this plate. So a couple of months ago, I don't know if you guys remember, the last thing we heard about Tully was that he was demoted. He was demoted from the title that he had at one point, which was whatever, superior detective supervision, I don't know what, to plain detective. That's the last we hear. So to put it into perspective, how come is it that some things only take 3 to 4 weeks and suddenly happen after a hearing reveals that Brian Tully is going to be deposed on May 7th? But then when it came to Proctor back in 2024, and to be exact, it was July, when he came to Proctor and everybody knew that he was going to be fired, there was a process which took place and everybody got involved, including the union. And that process took over 12 months before it finalized and actually ended up announcing that Proctor had been fired. So you're telling me that both processes, even though they're very different, one is putting somebody to get fired, and the other one is requesting retirement. How old is Tully? Let's start with that one. Does he have the age requirement? Does he have 30 years with MSP? Because for civil service employees, right, which is what they are, all the MSP, like people that are working in Norfolk County, Colleen Crawford, Fanning, all of them, they are civil service. That's what they're considered. So how is it that you are easily putting in, did you send an email to Morrissey? So Morrissey talked to Maura Healy, and Maura Healy talks to Jeffrey Noble and make it happen before you're supposed to be deposed? Are you kidding me? So what is it that they're anticipating? That the whole MSP is going to go down through the cracks and they're trying to put themselves ahead of the game? It doesn't matter if they try to anticipate what's happening. You know why? Because everything that is going to come up is going to ruin, furthermore, the reputation of the Massachusetts State Police, which is facing, this is one of the least things they should be worried about. We have Enrique Delgado Garcia, which they have these 3 idiots, the 3 musketeers, looking in front of a judge. No, Your Honor, I'm innocent, Your Honor. I'm innocent, Your Honor. Yeah, I'm guilty, innocent or guilty, innocent, Your Honor. And you have all the Massachusetts state troopers that were there backing up these 3 musketeers. Why do you think that happened? Are they hanging these 3? I'm not saying that they don't have any responsibility as far as what happened to Enrique. And I'm going on a tangent here, switching gears, but they look like idiots, like they had them there mocking themselves and facing something that partially if you are told to do something, do you think any of these three individuals would have stood up to provost, to other senior officers at the Massachusetts State Police that were yelling, finish him, finish him? Do you think any of these three idiots was going to stand up to any of them and say, no, I'm not going to do that. No, we're not going to kill him. No, that's going to kill him. We know what happened on the 11th. We know what happened. If we continue with this fight, he's gonna get killed. Do you think any of these three individuals had what it takes to stand up for one of their own? They don't. They don't. They're cowards. They're freaking cowards. They think that they are backed up by hierarchy, right? By the higher powers, by the powers that be. That's what they think. And standing there, taking a hit for their team, right? They think is still that somebody up there, higher up, has their back, that they're not going to let them sunk in, that they're not going to let them go to jail, maybe serve any time. Is that the plan? Is that what has been agreed upon? You look at the faces of these three people and you wonder, why aren't all of these people sitting and standing behind Enrique Delgado Garcia's family? Well, you know why? The same reason why they are letting Tully go. Not only have they demoted him, right? But you can tell by, if you go and you search the actual law, the rule and regulation, the Massachusetts General Law, the amended portion of it, Chapter 32, Retirement Systems and Pension, Section 28. That is the law. And it tells you all the requirements that you have to meet in order for you to be approved, to be retired, whether you meet the age, whether you meet the years of service. It tells you. Do they think that everybody is an idiot? Do they think that everybody that is listening to them, regardless of the fact that, it is legal to smoke pot in Massachusetts, do they think everybody's high all the time? That nobody has 2 inches of a brain to figure out what it is that they're doing? You're not going to be able to escape accountability for anything that comes out of Brian Tully's deposition. You are not gonna. Because while he did what he did and committed whatever wrongdoings we're about to find out, or failed to adhere to regulations and protecting the job, the integrity, the reputation of the institution that he represents, he's not, the fact that he's fired, the fact that he's retired, none of them will be able to just absolve any wrongdoings or take away anything that shames the Massachusetts State Police further. Nothing. You can let him go tomorrow. You could have just given him a paycheck and shake his hand. Nothing is going to absolve the Massachusetts State Police from all the atrocities, injustices, tragedies that people have gone through for years without nobody noticing until recently. And I gotta give props to Colonel Noble, because a lot of positive stuff and accountability, and he has stood up and he has faced the camera and he has talked to a lot of people and made a lot of things public, saying that he will not stand up to all of this crap and he is tired. He's had it. But you know what you are missing, Colonel? You are missing a hard hand on these people. You're supposed to set the standards high. You're supposed to set clear expectations of what it is that you expect as far as the behavior, the conduct, the performance of all of the people that are under your umbrella. Because every single one of their actions, their lack of actions, their wrongdoings, their good deeds, all of it goes back to, guess who? You. During your term, it goes back to you. And I understand that you have to lead by example. And I understand that what you got was a broken system with a growing cancer that you could not put a stop to it. I understand that. But at the same time, clean the damn house. Show them how it's done. You're not going to abide by the rules. if you're not going to adhere by regulations, if you're not going to comply by what it is that a Massachusetts state trooper is supposed to be, then clean house. Show them. Don't just tell them. Don't just tell them. Show them. That's how some people learn. You show them. You show them how they lied. You show them how they deceit. You show them how they gaslight their way through. You show them what it is that it will not be tolerable within your reign. That's what you do. That's what my dad would do. That's what anybody with background in the military would do. Stop with this sissy shit. You got a bunch of men that you're putting each other to fight to figure out whether they're worth it. Worth it how? Their muscles? They're what? If they're worth it, for what? To then go back and bully people and get away with doing whatever it is that they want to do? Is that what the training exercises are for? Because if you ask me, you are teaching and training a bunch of parasites that are socially incapable of understanding what it is that is called from them. They're public servant. Public. P-U-B-L-I-C. Public servants. Do you know what that means? Do you know what being a public servant means? It is the public you serve, not your own. It is the public you protect, not just your own. It is everybody out there, societies, communities, the mothers, the children, the ones that cannot protect themselves. You are supposed to stand up for them. But then you want to change public opinions, right? Public trust. You can't change it. You're going to have to build it from scratch because it's non-existent right now. So this joke that the issue date for approved retirement for Brian Tully dates April 9th, but it's effective the 8th. Did you think I was not going to catch that? Do you think I was going to be like, woohoo, let me go smoke a doobie and be woohoo, so everything goes by and I don't notice anything and nobody calls out anything? Well, no, not me. I don't smoke. I don't drink. And when I drink, I make sure that I'm at home. So anything stupid that I do, you know where it's going to stay? At home. It's not going to damage my reputation. It's not going to damage my thought process. It's not going to stop me from identifying when shit like this happens. Because who is so stupid to actually write a personal order and date it on April 9th and make it effective retroactive to the 8th? Who does that? I don't know what to say. But the worst thing is that if you match that personal order to the fact that there was a hearing that pretty much the judge put everybody on point and asked them who's going to be deposed and when. And that's when everybody found out that it was Brian Tully's turn for 3 to 4, 5 days. And I don't know how many lawyers were going to interview him. So did they want him not to be a Massachusetts State Police by the time that he took the stand and said whatever it is that he's going to say? Are they trying to make sure that whatever he says under oath, and do you think, that's another thing, do you think under oath means anything to these people, to any of them? It's almost like the whole thing has lost its connotation. There is no gravity. Nobody fears. There's no grave concerns, right? Let's quote Auntie Beth. No grave concerns as far as sitting on the stand, on a witness stand, in a court of law, in Massachusetts, nonetheless, taking the stand and play like stupid, like, oh, I don't recall. And it doesn't matter if you're lying because under oath doesn't mean crap anymore. Seriously? Seriously. Well, guess what? For some of us, it does. It does. Under oath means under oath. It means that if you lie, if you commit perjury, you also have to face the consequences of it. This is so annoying to me because it's like, I can't wait. I'm sure somebody, I'm waiting for, another one of them lawyers. Let me finish watching. I love Andrew Myers. Let me finish watching this. Let me see if you can hear it.
A protective order was extended regarding Janet Reed, William Reed, and Caitlin Boutreau, that there would be no depositions or discovery of them for either 90 days or the end of the criminal trial. So with respect to the fact that the depositions with regard to those important parties were in fact stayed, I don't know, it just seems a little bit, kind of the judge is in a hurry. That's all I can really say. The judge is really in a hurry. And
he might have fire under them because he wants them to move it along. And maybe when the time comes, he might allow, an extension of discovery. But for now, he's trying to get them to move.
Yeah, I wouldn't count on it. I think from my experience doing civil litigation for over 30 years in Massachusetts, I think that discovery deadlines are enlarged for good cause, but I wouldn't count on it from the tone and tenor of these status conferences. In any event, I'm just wondering what our fine commenters think. Do you want to take the odds or evens this time?
Take the odds.
Okay, you're on.
This is from Sick of You.
Don't take it personally.
Where would someone get the information from to write a handwritten email? They would have to copy it from the original, therefore it's a copy.
Did you follow this in our comments? Remember I said, or you said actually, when the court in the other case said they did not want anyone keeping no, it was this case actually. The judge said he wanted Karen Reed's errant, mistaken reply email to Attorney Diller. He wanted them to delete all of them. And you said, and I agreed with you, well, that wouldn't prevent them from writing out what it said. And oh my God, we got a storm of comments from people saying, well, that would be a copy if you wrote it down. They would have to copy it from an original, therefore it's a copy. And I disagreed vehemently, but what do you think about that?
Well, it depends on what the court means by copy of an email. So if you just take the words, just like when you interpret a statute, you just take the words as they read. A copy of the email would be, you print out the email, that's a copy.
Right.
You put the email in a Xerox copy machine and you copy it, that's a copy. But when you're handwriting it, that's not a copy of the email. That's your handwriting of the email. So a copy, depending on how it is used by the court, which typically you can argue about that, but a copy is a printed out copy, a Xerox copy of the email itself, with all of the identifying factors, to, from, date, all of that.
So in other words, what they're trying to say is that even if there is an order, right, to destroy or avoid using whatever, like get rid of it, if there was a printed copy of it, the specific order from that judge does not include printed copies that they already have. So it wasn't very detailed as far as what was it that the judge was ordering the attorneys to do with the email that was, replied erroneously.
So if you just handwrite what the email says, you are technically not in possession of a copy of the email.
I agree 100%. And that's what I said. And a copy is something you take and you put in the photocopy or press the button and out comes a likeness, a true and accurate likeness of what it is, or a scanner. I have a scanner on my desk. I scan stuff in and I get an absolute perfect copy of it. That's a copy. If I sit there and write stuff down and I present that in court and you're the opposing attorney, Yoli Medina, and I say, oh, well, this is a copy of his statement, you're going to object all day and all night because it's not a copy, aren't you?
No, yeah, it contains handwritten notes that the opposing counsel wrote, which could contain other things.
Yeah.
Right, exactly.
Right?
So it's not.
I mean, it's not a copy.
So, yeah, I went back and forth with some of our commenters. They're entitled to their opinion. That's fine. I looked in Black's Law Dictionary, but it pretty much solidified what we both just said, but it went on for pages and it cited Kentucky law and it got who knows what else. So,
Well,
no,
the word copy in legal, like the way that I would understand it is like you understand it, is an actual copy of the email with a to, from, here. But notes, just jotting down what the email said, is not a copy.
Exactly. The photocopier and the scanner are, or if I take a picture of it with my cell phone, that's a true and accurate copy. All right, number 4, we beat that one. Terry Parnham, please keep in mind that police body cams present an imposing dilemma within police culture. Generally speaking, cameras provide a very public look into the range of daily quick decisions, judgments, and possible mistakes that confront all law enforcement officers. Times and technology have turned that and the secret society world of policing over to public scrutiny and insight where it belongs. That ideal reality doesn't sit well with the old guard. Police culture has to change. Thanks. Interesting comment.
Yeah. Well, I think it's good that it provides a very public look into the range of the daily quick decisions that officers have to make. Because I've watched these body cam shows where it's so intense, and you could see why an officer would do something in such a situation. And if you don't have the body cam, then it sort of makes it difficult to understand what the police officer was facing, right? So I think
100%,
it protects them. It protects the officers more than it hurts them, because when there's no body cam, when there could have been body cam, then I always think, well, they could have had body cam. Why didn't they?
Yeah, and with respect to the fact that they're quick decisions and judgments, I understand that. But the thing is that, maybe if these body cams of quick judgments and decisions are used in training, I mean, we attorneys have to go to continuing legal education all the time. And one of the things we look at is trials and appellate decisions that point out where errors were made in trials. And we're required to go to those. Why shouldn't law enforcement take a look at other body cam videos and see, this is an action that was undertaken, quickly, but maybe the next time something like that happens, maybe we can all analyze and think. I don't know.
Yeah, to learn from it, right? It's like,
exactly.
People make mistakes, and even appellate courts can make a mistake in their ruling or decision, which the Supreme Court overturns. Because, if appellate courts can make mistakes that the Supreme Court overturns and says this was a mistake by the appellate court.
Guess what else was a mistake by the appellate court? Well, not by the appellate court, but by Massachusetts State Police. That memo, that was a mistake. They shouldn't have done that. That is Attorney Andrew Myers and Jolie Medina. Andrew Myers is in Massachusetts, but Jolie Medina is in California. That's what we were talking about. That and we have no idea, because we were talking about the fact that the memo that was shared announcing Tully's retirement was dated, or actually, yes, it was dated on the 9th, which was the same date in which Karen hearing happened this last Thursday, but then it makes it effective on April 8th, almost like a preventive measure, because they are anticipating of, all the chaos that's going to happen. I'm going to try to share this with you guys, but Tully's name shows up 61 times on the Karen Reed. Let me see if I can. Okay, so Tully's name shows up at least 61 times, up to page 21 of the 54 pages motion that Karen Reed entered into the courts on the 13th of March. Brian Tully's name shows up 61 times. I didn't finish counting. I only counted until page 21 because it was getting exhausting, right? But I'm gonna see if I can share this instead. And I don't know how TULLY managed to request that retirement right after he got demoted not long ago, and all of a sudden it's approved by Jeffrey Noble. It just, some things don't make any sense to me. It's like, how does this happen? How does this happen? Okay, can you all see that? Let me see. I gotta see if you can all see that. How do I? Wait, perfect. So I'm going to, let me see if I can make it any bigger. I was hoping that it's too early. I mean, Howie Carr just shared that, I think it was yesterday, announcing that Jeffrey Noble, you know, oh my God. It is so annoying to me. It is so annoying to me that nobody's cashing or calling out this stupid moves and actions that these people do. And they're able to continue to do them without any repercussion, nobody calling them out. It's like, so were you listening to that, to the hearing? Did you hear that Brian Tully was going to depose for 1, 2, 3, 4, 5, potentially 5 days? That there were several lawyers that were going to be asking questions and this and that? Is that what provoked the quickly announcement of announcing that Brian Tully is going to be deposed coming up pretty soon? So you rush to what? To what the heck? It just pisses me off. But I'm hoping, one of the law tubers soon does one of the shows, and I know it's Saturday. I just couldn't wait because I didn't know whether everybody caught the dates. And there's no signature. There's no signature on that letter announcing that Brian Tully is. Oh, Jesus Christ! Like, oh my God, where is the Inspector General's office when it comes to Massachusetts? Where is the OIG? Where are all these inspectors that don't have to announce that they're about to go in and check everything? Not like the Canton audit where everybody said, okay, you can only look at this drawer and you can only look at this tray. Everything else is off the table. No, an inspection is not done like that. An inspection, a correctly done inspection, you don't announce it. You just say that you're going to be auditing their whatever in the next couple of 6 months. And when they least suspect you, you show up. And you have access to every single thing that you want. You have access to every single drawer, to every single archive, to every single electronic file, and you can trail back paper. Do you know how easy it is to move money, hide crap, and hide stuff with paper? It's the hardest, the easiest and the hardest way at the same time. Because it is so easy in paper to steal money. It is so easy in paper to do the wrongdoings. The other day, the district attorney's office in Boston announced that, and I'm going to pull it up because I don't want U.S. district attorney, announced that there were $10 million. Somebody was finally apprehended and, brought to justice because $10 million in overtime fraud. How does that happen? How can somebody get away with frauding the government with $10 million in overtime fraud? Can anybody explain this to me? For overtime to occur, it has to be pre-approved, right? You need to pre-approve your regular overtime. Unless it's an emergency overtime that just happens, then that's different. But there are regulations that cover the processes of both. If there is regular overtime because you have to stay in a continuous basis 2 more hours every day to learn a trade or to catch up with payroll or to audit something or to train somebody that is in transition from one job to another, then that's regular overtime. And Title V of the regulations set clear standards to be followed to meet the requirements to get paid for those hours of overtime. If it's the regular overtime, then that's something different. But what I'm trying to say is you have a payroll person that does the payroll. You have somebody that actually audits your payroll. Everybody else in different departments does their own payroll, right? And then the payroll person is the one that gathers all the information, audits the whole thing, and sends that payroll to the U.S. disbursing officer, either in Washington, D.C. or at the Flexi in Charleston, South Carolina. You have two people that at the end of the day are going to collect everybody's payroll on every 2 weeks, every pay period, right? 26 pay periods on a given year, unless it's a leap year, and then you have 27 pay periods. It doesn't matter. What I'm trying to say is, how can an overtime fraud go past a month? How can it become a $10 million fraud in overtime? Do you know what, like, when you put it into perspective to somebody who knows a little, that means that the payroll person had something to do with it, right? Had to, because she or he has to audit this thing, right? The person who prepared it did too. The person who signed the overtime did too. The person who's claiming for the overtime did too. The person that they send it to be audited as a whole, right? The whole package, the whole file had to know, because how can they overlook that? And let's say that they're humans, right? Just like Jolie Medina just said, we're all humans. We make mistakes. Let's say that it happens one pay period. Okay, that's a mistake. I understand that. How can it happen $10 million later? Over the course of what? 4, 5, 6 years? How can you get to 10 million on overtime as a fraud? Not being caught by an auditor, by somebody who's doing their job the right way, by the U.S. disbursing officer, by the person, the other office in South Carolina. How can that go all the way to $10 million? Explain that one to me. We are lacking integrity, leadership, and accountability in Massachusetts. And that's no news to anybody. I mean, I'm not breaking anything here, right? I'm not breaking any news here. But this is just ridiculous. The things that continue to happen over and over is ridiculous. It pisses me off because I am a law-abiding citizen, because I did federal government for so many years, because I was by the book, and I was walking Bible Josie, and I wanted everything to be perfect. If I made a mistake, I was the first one who would rush. I would freaking rush to call anybody. Whoa. Or get ahead of the game and say, I made a mistake. I made a mistake. Why? Because that mistake I made could have cost millions of dollars. That little mistake I could have made, if I didn't raise the hand quick enough, it could have cost millions of dollars. And when you are committed, regardless who the damn president is, when you are doing your job with integrity and love for your job, for what you're servicing, for what you're doing for your country, for the people, for public service, you want to give it all you've got. You got to put in all of your heart into it, all of your honesty into it, your integrity into it, and you're the first one to stand up and said, I made a mistake. Because by doing so, what do? You avoid further repercussions. You avoid further consequences that will affect not only you, anybody makes mistakes, but what could happen if you don't stop it on time? So, this is annoying to me. I'm not sure if you guys know, but I'm dealing with one hand. So I'm gonna keep this one short. Oh my God, it's already been an hour. But it is a Saturday. Enjoy your Saturday. I was in the middle of planting and replanting my tulips, and somebody called me to alert me about this how we carve thing. I've tried not to be so much on the electronics on my hand because I'm trying to heal this thing. I don't want to get a surgery on my right hand side. So I'm going to keep it short. But I thank everybody that made me company and came in and said hello. And I'll catch you up later. I hope nothing else happens this weekend, but I'm not doing much. So if something happens, I'll probably jump in and say something because that's who I am. So, you like it, you hate it. That's who I am. Have a good weekend, everybody. Enjoy it. And I'll see you all soon. Yeah. Bye-bye. Ay.